Okay, here we go. Hello. Hello. Welcome. Just trying to get myself sorted out. I'm back. I'm back to my old place. Now that I do have a new tripod. Hello. Oh, yes. There's a lot of stuff to learn about in this complaint here. I thought, you know what? I think almost we can do multiple pieces of that business here. But I do want to go grab my rule book, so I'll be right back. Okay, here we go. We've got to have our rule book, right? Whew, I'm doing okay. It's weird. Today's been a weird day. Today has been a weird day. And not like a fun weird either. So yes, but I thought I will, and I'm sure I can remind everybody, but hello, Xavier. I'm feeling okay. One foot in front of the other. Hello, so unique. Good to see you. So yeah, it's odd. Now let me just put this out there first, everyone. So for anyone who's new, there are a lot of people going through the epi files. I don't know, should we call them epi files? The epi files. So there's a lot to them. Now, when the last time they had put out a whole bunch of files, and this is when Under the Desk was over here on the talk most of the time, but they are over on the YouTube. They're still here, but they're over on the YouTube pretty strongly. But V really grabbed that bull by the horns and went through all of that first few sets of paperwork and did a great job explaining it. But now we're in a situation where we've got a ton of more paperwork. So we had a few emails that were shared. Then we had, I don't know, what was it, 20,000? I don't even remember the number, but a whole bunch more. Now, my stance on Mr. Epi here is the same that it's always, oh, thank you so much. I appreciate that, Toodle. I like them too. I tell you, they're just kind of for funsies. So, e-files. All right. So before, though, if you're new, if you've not been hanging around, I was a prosecutor for several years. I was also a criminal defense attorney, did a lot of family law stuff, did a lot of juvenile stuff, along with, a lot of other stuff. So I was kind of, so I did a lot of that. And part of what I have done previously has been to work on SA cases, either as a prosecutor or a defense counsel, or even just as I was clerking. And the SA cases are so heartbreaking. They are just so heartbreaking. And there's a couple reasons why, as I give you my spiel here. First, when we have an SA case, let me just, I'm not going to put a warning here because I'm not going to be giving any details, of course, but I do want to explain. If we've got, all right, so for normal crime, let's pick a crime. Anybody pick a crime? Send me a crime. Oh, yes, please do share the live, everybody. I appreciate that. I need to remind people to do that more often. It's tough. Yeah, it's a tough road on the SA, but it's, you got to do what you got to do. Okay, robbery. So we've got robbery here. Robbery is the unlawful taking of some kind of property situation. with a person, okay? And there's a person involved. Burglary is when you just go into the house and you're like, I'll take that and I'll take that. But burglary is like, you're like, give me your wallet, right? It's pretty, yeah, Grand Theft Auto. Oh, yes, thanks so much for the shares, everybody. I did not realize that so many people were not getting the notice. Anyway, long story short, I know, too late. But when you go in and we have a charge, typically, if you are the prosecutor and defense counsel, what's going to happen with this robbery case, if it's just run-of-the-mill, purse snatcher type situation, then you're going to have some plea negotiations, right? Primarily, and I may be a little off with my numbers because it's been a while, but I would say 92% of criminal cases will plead out. So we're only seeing about 8% actually go to trial. All right, so in SA cases, we're around that same amount. So I think we're at about 90%. That might be a little bit. This is estimates that I'm putting in, just ballpark numbers here, okay? The numbers aren't important. It's the distribution of the numbers, okay? So 90% of SA cases will, and that's not even right. Hold on a minute. And it's way, way lower. We've got to have it higher up here. So let's go like this. Let's just make it into an 8. All right, so 98% of SA cases will plead out. All right, so they'll plead to something different. Usually try to get jail or prison off the table is what we try to do as a prosecutor. So then we're looking at 2% of SA cases that actually go to trial. And again, my numbers might not be exact, but it's the proportion here. Almost all SA cases settle. And so this little tiny amount gets to trial here, all right? And then again, with our regular criminal cases, there's a huge, in the 90s percentage of cases that get settled. They're pled out, and then we have the rest of the trial. What's unique about the SA cases here, when you go to trial, is that, and then again, my numbers are just a little bit off here, but I'd say 97 to 98% of those cases, the defendant is found not guilty. It's an anomaly within our criminal justice system, because regular crimes, you go, and I always say, if you've got a jury trial, you've got a 50-50 shot. All right, 50-50, doesn't matter how good your facts are, 50-50 for a criminal case. But if you have an SA case that you're putting in front of a jury, the chances of you winning that, yeah, they're like, 3 to 5% of winning that case. The biggest reason why, and I think we can tell, I think one of the biggest red flags is who is in the White House right now, right? Because that is a bit of an idea of how our, peers feel about this kind of stuff. So it's heartbreaking. It's absolutely heartbreaking. And the primary reason is, of course, the credibility of the victim. And that, that's what we fight in all crimes. We have to make sure that our victims are credible, but for SA cases, it's complicated. Juries tend to want the perfect victim, and there is no perfect victim. And I know we use the phrase survivor, and I love that. But when we're going through the legal process, we would refer to that person as a victim. All right. So the credibility of the victim, we had included in the Federal Rules of Evidence 3 special rules that we would use for SA cases. That only apply in SA cases. All right. And it's 412, I think, 413, 414, if memory serves. Those are the rules, and those specifically set out that you cannot use the prior conduct of the victim. You cannot do that. There's specialty rules. Oh, here they are. Let me just pull it up here, make sure I got the right numbers. Here we go. Again, just an FYI before I dive in here. I know I talk a lot extra, but, that's just how I am. All right, so it's Rule 412, okay? Now, I'm not going to read it out loud, but if you are interested, this is where we have the Shield, RAPE Shield acts that were really big in the 90s. And then we saw that put into our rules of evidence. We've got Rule 412 here, and then Rule 413. This is what we call the modus operandi rule here, which is you usually can't use prior bad acts. Usually that's not allowed because they don't want to get it messed up. Like maybe you did this before, but you didn't do it now. But there's an exception, and the exception is in SA cases here, where it's the same MO each time. The process is the same, and there are multiple victims. And then here, and then 14 is children, and then 15 is also children. So, and I'm not going to spend a lot of time on that, but the reason I want you to know that is because these cases are so hard to win. And it seems like right now a lot of people just didn't realize that, especially with the Me Too movement, where that got a lot really wonderful things, a community built together, and accountability too. But then once we put the big flashy moments away and you step to the side, when you get into what's actually happening out there, our stats are skewed so much when it comes to SA versus any other crime. So we know as prosecutors or as defense attorneys that it's best, almost always best, to settle the case, to plead it out, because that 50-50 chance of all criminal cases does not exist in my experience, in my understanding of my cases, does not exist for SA cases. All right. And when I say SA, I do also include children in that. Okay. Right. Right. Exactly, Kaya. Exactly. But with that, I spent a lot of time doing DV cases. I've done SA cases and children cases, which are the most heartbreaking. I would say the youngest victim that I have ever worked on a trial for was 5. So they're heartbreaking. And because of that, I do not spend much time going through SA cases here. All right. So there's a lot of information, and it's incredibly important out there regarding this situation. But for me, I will just give you kind of a quick overview, but then I just move out of that area because, I did the real thing for years. And it's just, I definitely got out because I'm like, do you want to talk about a murder case and what's going on in the morgue? Let's do that. But if it's an SA case, it's too heartbreaking. It's just too heartbreaking. So this is one thing, though, that I did pull. I think everyone should be educated about what's going on, and, pull the information if you're interested in it, and go do some research. I think that's fantastic. And if you want to ask questions too, if you're like, is this okay, or what does this mean? Feel free to ask those questions and put those into any of the comments on any of my posts, and I'm happy to answer that. But I won't be spending a whole bunch of time going through the documents. There was one I was looking at that I think is probably the only one that I'll go through, and that was the deposition for like the Shapiro guy, I think that's his name. Anyway, it was a deposition, and the deposition's so interesting because he's like, when attorneys get deposed, they're such jerks. And he was quite the jerk. So yes, you are absolutely right, El Jenny. You have to protect your mental health, and as we get older, we realize how important that is, and you just have to recognize that. So 60 Minutes Australia. Really? Okay, interesting. Okay, so, and of course I have hot cocoa tonight. Why? Because it's crazy. This is a letter that was written to a Congress, to members of the Senate and the House of Representatives. Again, I'm not going to give any details of any wrongdoings in this area, all right? But this is a letter that they wrote and they signed, asking to say, hey, we need these files released, and we need you to be bipartisan about it because this is such a big deal. So, of course, we have multiple people who had been severely harmed and then signing it on the back. And I'm going to kind of cover this here. All of this is public information, but for me, I just feel better not sharing the full names here. But then they did sign here. So if you've not heard of this, this is one of those like later breaking, things that's been done since Congress is back in session. So this is available online. You can look it up yourself and screenshot it here if you're interested. And well, yes, hot cocoa is the best of all of the cocos in my opinion. But so there it is. So I'm definitely watching, but and much like too when we had the P. Diddy trial in New York as well. That was just too much, too much awfulness. So, and you can get really, it can really mess you up. A lot of our prosecutors that do domestic cases or that do SA cases or specialize in those kinds of cases, they're just at another level. Usually you can do 2 to 3 years before you fully burn out. But anything more than that, it's like you have to actively pursue keeping your heart from breaking. Order to investigate Clinton. Will they use that to refuse the release of the files? Well, good question. And right, this is why we choose a bear. Absolutely, absolutely. Although don't choose a bear that's super curious. My husband is so curious. We got our roof done today, part of it, and kept walking around and he's like, are they supposed to do that? Are they supposed to do that? And I'm like, dude, if you're curious, go outside. Because he's like a big honey bear. He wants to know all the answers to everything. I'm like, get out of the house, dude. You're driving me crazy. I digress. Sorry about that. So if we've got an open case, an open criminal case going, if there is evidence out there that has been kept under seal or is somehow privileged or something like that, that may be kept from the public because it might be used in a trial. But courts don't like to do that. They want to say, hey, if we absolutely are going to be using this, this is fine, but you can't go in with a fishing expedition and just pull everything you want so no one can see what it is. And also, so just to slow my roll here, I've got too much sugar going on. But so yes, it's possible. It is absolutely possible. That's right, VC. That's what I'm saying. That's right. We're paying somebody else. I tell you. Okay, look, I tell you, we have been, for anyone who doesn't know, my husband and I have been together for 30 years and we've been married for 25. So, so he's always been a curious bear. And when I was younger and was like, wearing a lot of leather, the phase, ladies and gentlemen and friends, I just didn't have time for it. I'm like, you go get your own answers. I'm done. Right. I'm not going to answer your questions. But now that he's older, it's like he's just, like this little bear. I'm so curious. I want to know blah, 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 blah. And it's, to me, I just look at him. I'm like, oh my gosh, hilarious, but get out. Anywho, you remember, right? 31 years. Yeah. Well, let me be perfectly clear and then I'll kind of dive in here. But let me be perfectly clear. I do not think everyone has to get married or everyone should get married. And quite frankly, the way the world is going, you just don't need to get married anymore in a lot of situations. But of course, we were backsliding, so some people may need to. Anyway, I'm not trying to say get married. That's how you fulfill yourself. That's not true at all. If you want to, great. If you don't, that's great too. And my husband even goes further, and he's like, I do not recommend marriage. Like, we'll go out with friends, and we'll get to talking about marriage, and he's like, let me just tell you, nobody needs to be getting married around here. Oh my gosh. I know. Then he tries to get out of the doghouse. Oh, yes. Well, anyway, so 59. Oh my gosh. Love it. Right, exactly. Right. It's not, that's a him issue. That's a skill issue for him. Anyway, moving on. Just that was a little precursor here when it comes to SA cases. I see it. I hear what's going on. I do not really follow it. And honestly, it's the same with what's going on in the Middle East. That particular level of horror is too much for me. So just be content. That's right. Single proud, keeping it that way. Sweet. Now we know where the party's going to be right there. Who's going to have the best charcuterie board? I think we know who. Oh, love it, love it, love it. All right, so tonight, because I didn't want to lean too heavily into the, epi stuff, I thought, you know what else is interesting? This Lindsay Halligan lady. Now, I have been having a very fun time hanging out with Kendrick. I apologize. I don't know what his full handle is, but Kendrick, who has been kind of like, who's this Lindsay Halligan person, as well as with Mr. Mayo, too. They've been talking about it quite a bit, off and on. So I thought, where is that ethics complaint? Then here we go. We got it. She hasn't been disbarred yet. No. He is great. Right. It's all right. Oh, the single ladies. That's right. You got to do the dance with it, right? Ooh, doot, 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 doot. Oh my gosh. Oh, thank you so much. Yes, I do. I do love them. I get them off of Etsy, and they're from lots of different small businesses around the world. All right, so I'm not going to call him that. I can't. Not after the dude wipe situation yesterday. You know what I'm saying, Kendrick, if you're here. Oh, my goodness. All right, let's dive in and take a look. Now, her license is out of Florida. One thing with Florida that we've learned because of Bondi is that the Florida bar will not go forward on investigations when you are actively in your job. All right. So she is a U.S. attorney, right? The only one that would sign the indictments that were ridiculous. That was her. So they pulled her in. She was a loyalist. She doesn't know what she's doing. And she's like, well, I'll sign it. I'll take care of it. Sure. And so they're like, dude, that's not right. So we've got an ethics complaint that's been filed against her. Will it go forward right now? We don't know. It depends. If she loses her position, yes. If she's put in a different position in the federal government, now we're looking at more of a gray area. So basically what we're doing here is we're keeping track here of what's going on. So we're taking down the information, making sure that it's ready to run, ready to roll when the Florida bar is doing their job or whatever it is that they do to take care of that business. So here we go. Let me make sure I have my little, I know ASMR, everybody, I apologize, but understand that. Yeah. Oh yeah. I understand too, where you don't want to the big thing. I know this is ASMR. I'm sorry. Oh, here we go. Shh. It's just my little minute. Anyway, they don't want to reflect negatively, right, on the position. Because if you've got an attorney general and they're like, well, we've got an active ethics investigation going, that's really going to hurt her credibility in her job and the country. So they're kind of careful about that. Does she have to be part of the Virginia bar to be a state's attorney of Virginia? Good question. And I think that's a really good question because I think you just have to be licensed, but I'm not 100% because DC, they'll take any license. And technically, this is the federal level. So we're not dealing with state law. So because it's federal, I'm not sure. I don't think you need to be, but typically they pick people from the area to be the U.S. attorneys for the area. All right. But that's it's an excellent right hurdle to mention. Oh my goodness. All right. Now we have made it through about halfway of Pam Bondi's ethics complaint by the American Bar Association. So let me make my sticky note here. We have, again, this was November 11th when this was filed. So November 11th. And this is an ethics complaint here. This is such a great learning opportunity when these attorneys get called out. I think it's great. I mean, some people are like, oh, we're all part of we don't have a blue shield we're protecting here as attorneys. We have ethics, and each one of us has ethics. So it's actually explaining who you are and how honorable you are if you go forward or not. So again, this is Lindsay Halligan. Some people said she was like in a beauty pageant or whatever. I mean, I don't care. If you worked in a garage, whatever. Either way, whatever jobs you had, you had. And so that to me is not I don't think that women and again, women, because I don't pay attention to the men's pageants. Sorry. But if you are in some kind of a pageant, then I'm not going to say you're just not intelligent or anything like that. I don't think that those kinds of things are rated that way. Review the grade. Yes, so ours are missing. Okay, Snarks and Larks, listen. Bondi lied to the court saying she reviewed grand jury transcript. Ours are missing no court reporter. That's huge. That's a huge, huge, huge thing that they're fighting out. And I've got no definitive answers for what's happening there other than in my area, if I had done that as a prosecutor, heads would be rolling. And it'd be like my own head would be rolling. All right, so let's dive in again on the 11th here. Enter pageants to win prizes to pay for their college. Exactly. I mean, it's a scholarship, right? It's a scholarship contest. Sorry, the Sandra Bullock movie just came. I don't care. I mean, that's, whatever. Live your life. It's fine. Just, do it legally. Secret. Oh my God. All right, here we go. Complaint against Lindsay Halligan, Florida bar. Here. So this is her bar number. Dear Intake Council, Campaign for Accountability, which is this organization here. Section 501c3, which is the same section of the code that churches use, religious places use. A nonpartisan, nonprofit charitable organization requests that the Florida Bar and the Virginia Bar investigate Lindsay Halligan, a Florida licensed attorney, and the attorney the Trump administration has stated is acting as interim United States attorney for the Eastern District of Virginia for potential violations of the Virginia Rules of Professional Conduct. That's interesting. So it says she's only licensed in Florida, but, the location where she's working is where the rules are that are being violated. And rules regarding the Florida Bar related to the prosecution of former FBI Director James Comey in the case U.S. v. Comey here, and New York Attorney General Letitia James in the case of U.S. v. James here. So both of those cases, because Miss Halligan is a member of the Florida Bar, but has been providing legal services in Virginia, both state bars have jurisdiction over this matter. Well, that's interesting because if she's only licensed in Florida. All right, so bump down here. Now, I don't know what Virginia's rules are when it comes to, who's on it and who's not. But here's the link of the rules that they're talking about here. Choice of law provisions in the rules of both state bars provide that because Ms. Halligan's actions took place in Virginia, the Virginia rules of professional conduct apply. By the way, all of our rules of professional conduct are almost cookie cutter, exactly the same as the federal rules. There are a few things that get changed around if your state does weird stuff. Like let me give you an example. If the spousal immunity or the spousal privilege, right? So if you're married, then you have to give permission in order to be testifying against your spouse. All right, that's what I'm using here as the example. Some states say only one of the married duo needs to agree. Some states say two, they both have to agree. So these little nuances in the laws in each of the states where like some do, some don't, that's where you will get little nuances of the ethics rules as well. But generally, we all have taken our rules from the model rules of professional conduct. Reciprocity in Virginia, I just don't know. I mean, I would think so. But yeah, I'm not sure. I'm not sure. And if anybody does a little bit of the Googling while I'm talking and let us know, that'd be great. If you wish to do that. All right. So through her actions and as set forth in further detail below, Miss Halligan may have violated, among others, Rule of Professional Conduct 3.3A1. So we've got our first rule that they're pulling out. And then I'm going to do a little test with this rule here. How long does it take for the bar to investigate an ethics complaint? It depends on the state. It absolutely does. If you've got a state where in the whole state there's only like 300 lawyers, right? It's probably not going to take as long as if you're like in the heart of it in New York, is what I would think. But the bigger area and the bigger number of attorneys that you have, it takes a bit longer. So hold on here. Let me just make sure, and we'll see if this is in here. We do, as attorneys, we do have to take an ethics exam before we're allowed to actually take the bar exam. So we do have to learn ethics. It'd be great if they would remember, but not everybody does remember those. All right, so let me just make sure here. It is. It's the same rule. All right. So Rule 3.3 may look familiar because this is the one that I think applies to like almost all of Orange's attorneys here. Candor towards the tribunal, and that's Rule 3.3. That's the rule they're citing here as well. So violation of a rule requiring candor to the court, and then Rule 1.1 requiring competence, which is another one. Like you've got to be competent to do your job. This was the big one that we were leaning on for Judge Cannon. For anyone who was around during that period of time, who received, this is the first time I've ever heard of this happening, but the bar received so many complaints about her that they said, we've received 1,000 complaints, we're not taking any more because we feel like everyone's just trying to say the same thing. So they just stopped taking them. Pull the paper down a little bit. Sure. Yeah, my screens, we talked about this before. My screens are a little different here. I don't want to block out the comments, so that's why I kind of am also a little careful with that, but there you go. Pam Bondi, they've already tried. They have already tried. Let me bump this up just a little bit here. Maybe this will work a little bit better. There we go. Can we see it at least, though, or is it too high? Yeah, the American Bar Association was like, hopefully we're okay here. Okay. Great, thank you for telling me. All right, then we've got Rule 3.6, prohibiting extrajudicial statements, so comments made outside of court. Rule 3.8, prohibiting the prosecution of a charge the prosecutor knows is not supported or by probable cause. This is huge. You're bringing in a case that you know doesn't have probable cause to go forward. You're just, this is the malicious prosecution road that they're walking down here. So here's all of our rules. And Rule 8.4, prohibiting conduct involving dishonesty, deceit, misrepresentation, or conduct prejudicial to the administration of justice. And this last one here, prejudicial to the administration of justice, you can get tangled up pretty big time if you're screwing around too much with that. They don't investigate attorneys while they are in an administration. Correct. That's correct. Yes. And that's Florida. Not all states do that. Not all bars do that. But that's one of the reasons why Pam Bondi does not have an open investigation going. It's not because people haven't complained, because they have. But they just don't do it if you are in an active role. It seems those ethics boards would rather earn an attorney than take against them. Oh, I'm sorry. I don't quite know what you mean, Blue Age. Okay. Would rather, befriend the attorney than be against them, perhaps? Is that what you're meaning? Because they don't. They don't care. They don't like us. Oh, Warren. All right. Well, they don't. I don't know. I'll come back to it. My brain's not clicking in. Transferred to Virginia, but it wasn't through reciprocity. It's a special appointment. Oh, yeah. Okay. That makes sense. Sure, because if she's appointed into that U.S. attorney position, sure. All right, that's making some sense now. All right, in addition to the possibly violating her obligations under the rules of professional conduct and RRTFB, I don't want to say that full piece the whole time. You know what I'm talking about, the rules and the rules. Miss Halligan swore when she became a Florida bar member to support the Constitution of the United States and to faithfully discharge the duties of the office of attorney and counselor at law. So and we all take this oath when we go into a jurisdiction. In the actions that have been reported concerning her interaction with prosecutors in her office and work with the grand jury, Miss Halligan may have violated that oath. And sometimes if you violate that oath, you can be charged criminally, like what we saw in the RICO case in Georgia. But sometimes your oath will only come into play in the ethics portion of our program. So that's some things to kind of keep your eyes out for. Next, here, more generally, Miss Halligan's actions appear to constitute an abuse of power. Again, that's a very, very bad situation. That's the worst thing that can happen as a prosecutor if they found that you have actually abused your powers. All right, that's you won't have any kind of immunity if that has happened. Here we go. Abuse of power and serve to undermine the integrity of the Department of Justice, the DOJ, which is compromised, and erode public confidence in the legal profession and the fair administration of justice. Finally, the Florida rules specifically provide that the commission by a lawyer of any act that's unlawful or contrary to honesty and justice may constitute a cause for discipline, whether committed within Florida or outside the state of Florida. We have our footnotes down here, and they're just citing again to the rules here. All right. Here's our background. Number 1. So make sure I get I also have Tang, right? Because you got to have both. All right, here we go. Background. Lindsay Halligan's appointment as interim U.S. Attorney's Office for the Eastern District of Virginia took an unusual route. Eric Siebert, a former police officer with the Washington, D.C.'s Metropolitan Police Department, who has served as an assistant U.S. attorney in the Eastern District of Virginia here since 2010 and had been nominated for the position of U.S. attorney by President Trump in May of 2025, had been leading the office. All right, so there was someone in before she came in. Mr. Siebert resigned, however, on September 19th upon learning that because he had refused to indict New York Attorney General Letitia James and former FBI Director James Comey after concluding evidence did not support either prosecution, Mr. Trump planned to oust him. The next day, Mr. Trump claimed to have fired Mr. Siebert. Yeah, he is running out of people. That's the thing, is that, there's not a unlimited supply. On September 20th, President Trump announced he was nominating Miss Halligan to replace Mr. Siebert as U.S. Attorney for the Eastern District of Virginia. And she was sworn in as interim U.S. Attorney on September 22nd. Prior to this appointment, Ms. Halligan served as a special assistant to, I know, shocking everyone, a special assistant to President Donald Trump. Before joining the White House, Ms. Halligan had focused primarily on insurance law and served as personal counsel to President Trump. She had no prior prosecutorial experience. So again, one of the posse here. Right. I agree. They're way too impulsive. All right. So no prosecutorial experience that can be overcome, but you don't want your first case to be like the trial of the century, right? Which is what we're talking about with these particular ones. Right. So, Andy, that just is like, what, are you a doctor? Because that's stupid. Next, investigations of James Comey. At President Trump's insistence, the Virginia had been investigating whether Mr. Comey had given false testimony to Congress about whether he had authorized a leak to the news media. In September of 2025, prosecutors subpoenaed Mr. Richman, a Columbia University law professor and friend and advisor of Mr. Comey, in connection with the investigation. Prosecutors found Mr. Richman's statements unhelpful in building the case against Mr. Comey. Right. Significantly, John Durham, the former special counsel who investigated the origins of the FBI investigation into Trump's 2016 presidential campaign and its alleged ties to Russia, told prosecutors that he had not found evidence supporting charges of false statements or obstruction against Mr. Comey. Virginia prosecutors also met with lawyers in the U.S. Attorney's Office for the District of Columbia, who also had investigated Mr. Comey, and they were unable to identify prosecutable charges against the former FBI director. Ultimately, Mr. Seibert was unwilling to seek an indictment, infuriating the president. Investigations of Letitia James. So again, this is like, this is absolutely some kind of, hunting down the people that have made him mad. And it's just so petty. Some people are like, oh, it's kind of cool, like, organized crime. But it's not. It's more like, I don't know if anyone ever remembers a Pinky and the Brain, right? That's old school, where it's like they're trying to take over the world because they're just, dingleberries. Ability for, really? Okay. Looked at Florida versus Virginia questions on ability for attorney to work. Okay, excellent. Thank you. The pettiest president in history. True story. That's absolutely true. Trying to take over the world. Well, right. All right. I digress. Here's Miss James. At the same time, the office was investigating Mr. Comey. Virginia was also investigating Miss James. Miss James had launched a civil fraud case against Mr. Trump and his company in 2022. Yeah, that was a while ago, leading a New York court to find he had overstated the value of his business assets to obtain favorable loans. Though in August of 2025, an appellate court overturned the roughly $500 million judgment, which we all knew would happen, including Judge Engeron. He knew that would happen as well, saying that was excessive. President Trump frequently expressed his fury over the case and railed against Miss James, calling her a, quote, corrupt and incompetent attorney general and a, quote, Trump deranged lunatic. Right? I think it's malicious, not petty. Well, that's a good point, but I think those could both be applicable here because I think petty implies a lack of maturity and as opposed to malicious. So it's like it's an evil intent, but an immature legal intent. How's that? We can mix it up. What'd you say? The hand art. Yeah, that's right. Oh my goodness gracious. Over the years, I have had so many students come up to me after class like, should I write that down or what? And I'm like, write what down? I'm like, just take a picture. Oh my gosh. Can appear out of state only via pro hac vice with fees in local counsel. Yeah, it's temporary. Thanks, Toodle. Excellent. Well, that clears that up then. The whole process. Then again, with the federal courts, there are a lot of people that come in asking to do that. He's definitely petty too. Well, yeah. All right, here we go. So shortly after President Trump, I'm going to start calling him Mr. Orange so I don't get in trouble with the algorithm here, everyone. Mr. Orange took office in January of 2025. AG Bondi announced the creation of a, quote, weaponization working group. end quote, tasked with reviewing the actions of those officials who had allegedly targeted Mr. Orange, including Miss James, Federal Housing Finance Agency Administrator Bill Pulte, and Ed Martin, the head of DOJ's weaponization working group. Okay, pressured federal prosecutors in Virginia to bring charges against Miss James for mortgage fraud. In April, Mr. Pulte sent DOJ a criminal referral alleging Miss James had falsified records pertaining to a Virginia house to get better loan terms, had misrepresented the number of rooms in her Brooklyn house to meet the requirements for a government-backed loan, and had falsely claimed to be her father's wife on a 1990s mortgage application. Seriously? Oh my gosh. That's a lot. Ugh. Okay, yeah, CPAs. That's interesting. That is interesting. All right, here we go. Mr. Pulte has publicly referred to Miss James as a fraudster for her pursuit of the civil case against Mr. Orange. Mr. Martin sent Miss James a letter suggesting she resign from her position as New York Attorney General, which is an elected position, right? And stating he would take this as an act of good faith. A few days later, Mr. Martin appeared outside Miss James' Brooklyn, New York home wearing a trench coat in August, posing for a photograph for the New York Post, and later posting that picture on social media. What a jerk, right? Right. Yeah, that's pretty crappy. Continuing the attacks on Miss James, White House Deputy Chief of Staff Stephen Miller, yikes, I think he's like the butler in the Addams Family, right? Called her one of the most corrupt, shameless individuals ever to hold public office, and said she was guilty of multiple significant serial criminal violations. Following the FHFA referral, President Trump said of Miss James, she's a disaster for New York. She's a horrible, horrible human being, and I think she's a total crook. Like, yeah, he does. Yeah, he's not. He's no Perry Mason for sure. Career prosecutors reportedly spent 5 months. Now, career prosecutors, that's important to note. Some people are prosecutors for their entire life. It's a special kind of person, so just note that. But their whole career has been prosecuting, so they really know the ins and outs and what's going on and what's going to work, what's not going to work. So they spent 5 months investigating her Virginia mortgage, interviewing more than a dozen witnesses, some of whom testified before a grand jury, but found no evidence Miss James knowingly made false statements to a financial institution to secure favorable terms on the mortgage. So that's like a really key piece here. 5 months from career prosecutors whom are, the experts in their field. The documents in Miss James's loan file for the mortgage accurately stated she would not reside at the home, but Mr. Pulte and Mr. Martin argued that another document, a limited power of attorney form, used by Miss James's niece to sign documents on her behalf at closing, indicated the home would be a primary resident. That form, however, was not considered by the loan officers who approved the mortgage. So it wasn't even put into the equation, right? So even if it was wrong, it wasn't used. When career prosecutors, including Mr. Seibert, declined to indict Miss James, Mr. Pulte encouraged President Orange to fire Mr. Seibert, and replace him with a more malleable attorney. Mr. Orange agreed, and on September 20th, in the apparent mistaken belief that he was sending a direct message to Attorney General Bondi, posted on Truth Social here. Oh my gosh. Again, this is Truth Social post. Pam, I reviewed over 30 statements and posts saying that, and posts, what the fuck's that? I'm sorry, language. I'm not sure what those posts are. I've reviewed over 30 statements. And that bothers me too. Like, what do you mean by statements? Like somebody's saying something assertively? Oh my gosh. And posts saying that essentially The same old story as last time. All talk, no action. Nothing is being done. What about Comey, Adam, Shifty Schiff, and Letitia? They're all guilty as HE double hockey stick, but nothing is going to be done. Then we almost put in a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. Oh my gosh. A woke rhino who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said that he quit and that we had no case. No, I fired him, and there is a great case. And many lawyers and legal pundits. What? Who are these people? Say so. That's not why you file something, going to say, oh, well, the guy on the Sunday show was like, file it. So I thought, all right, let's do that. No. Lindsay Halligan is a really good lawyer. Oh, dear. And likes you a lot. Well, that's important. Who's he writing this to? So this would be Pam Bondi, right? Because he didn't realize that he was writing it to everybody. And likes you a lot. We can't delay any longer. It's unaliving our reputation and credibility. There is none. Right? Mr. Orange does not have any reputation or credibility. Oh my gosh. They impeached me twice, and he's bitter, and indicted me 5 times over nothing. Justice must be served now. In all caps. President DJT. Oh my gosh, that's funny. I'm sorry. That's funny to me. She even, oh dear. Remember that. Ms. Halligan was sworn in less than 48 hours later. So quicker than the congressional person out of Arizona. President Orange likely was particularly anxious to see Mr. Comey indicted quickly because the statute of limitations for the alleged offenses was set to expire September 30th. 5 years from the date of the alleged conduct under 18 U.S. Code Section 3282. This is a huge issue. That statutory of limitations is, that window is so tight that if this does get dismissed and they have to refile it, I'm not sure they even can. I think they might be outside of the statute of limitations. So it's possible. The 34 felonies, well, that might be in here. We don't know yet. The Comey grand jury proceedings and indictment. Again, your indictment is, if we pull a grand jury in, they're only hearing one side of the story and determining if there's probable cause to believe that a particular person committed a particular crime. Probable cause is the same standard that you have to show in order to get a warrant, in order to make an arrest out in the field, in order to search a vehicle, those kinds of things. So probable cause is a finding of a low level of evidence, all right? So keep that in mind. Oh yeah, absolutely. They're usually incompetent. That's true story. All right, here we go. Although it had been reported that line prosecutors provided Ms. Halligan with a detailed declination memo explaining why probable cause did not exist to secure an indictment against Mr. Comey. On September 25th, just 4 days after her appointment, 5 days before the statute of limitations expired, Ms. Halligan personally presented the case to a federal grand jury. In violation of customary practice, no career prosecutors from the U.S. Attorney's Office. This is so bad. This is so bad. As a lawyer, this is like, whoa, you should not be doing this stuff here. Participated, and only 14 of the 23 grand jurors who heard the presentation voted to indict Mr. Comey. Ms. Halligan was the sole signatory on the indictment, again, departing from the Virginia custom that both U.S. attorney and presenting prosecutor signed the indictment. The grand jury rejected one of the 3 charges, returning a no true bill. Ultimately, Mr. Comey was indicted for making false statements to Congress in violation of 18 U.S. Code Section 1001A2. And, oh my gosh, did we get the, oh yay, we got the arm ones. Oh my gosh, thank you so much. That's the only thing I have. That's the only thing I have. So I don't. Oh my gosh, I just love it so much. Thank you, thank you, thank you. I appreciate it. That's my favorite one. I couldn't help myself. And as always, thank you everyone for the lovely gifts. Oh my goodness, too much fun. All right, backing up the truck here. No career prosecutors from Virginia's office have filed appearances in the case, leading DOJ to bring in two AUSA. So this would be, I think, associate U.S. attorneys. I think it's associate, but anyway, the next level down from the top one. From North Carolina to assist Miss Halligan. So we've got a North Carolina U.S. attorney in trying to help Miss Halligan with this case out of Virginia. Yes, a lot of people did. Yeah, they took out whole swaths of offices here. It's very similar to what we had going on when the Eric Adams situation was going on, right? So they're like, if you follow what we want you to do when it comes to immigration, then we won't prosecute you, and that wasn't good. So, oh my gosh. All right. Back in. This whole situation is just fascinating because it's so absolutely ridiculous. After Ms. Halligan secured the indictment against Mr. Comey, President Orange celebrated on social media, specifically thanking Ms. Halligan and FBI Director Kash Patel for their brilliant work on the recent indictment. Yikes. Southern District of New York. Yeah. Was it? Yeah. So here we've got assistant U.S. attorneys. Is that what you're talking about? Or Virginia? We don't have a New York involved. It's Virginia. They haven't gone after. Well, they might, Nancy. They might. The one thing, though, that's different about Alvin Bragg, real quick, everyone, who is the DA out of New York. The one thing that's unique about him is that before the presidency even occurred, so before before that November date, they had already gone after him repeatedly. They had multiple lawsuits they had filed against him. He had come back and filed against them for defamation. So they just dragged him all through every single possible situation before it even got to trial. So I'm thinking he just doesn't have the background that the others have that's open. So he's like covered because he's already gone through it, is what I'm trying to say. For Bragg. But yeah, they didn't like it. They asked the judge to recuse like 3 times. Bragg's like, what are we doing? Oh my goodness. All right, here we go. Kash Patel, who was basically called a liar in the Anderson case out of California. We mustn't forget that. The James indictment, as with the indictment of Mr. Comey, Miss Halligan is the sole signatory to the indictment of Miss James, and apparently unable to find a lawyer in Virginia here or the U.S. Attorney's Office to work on the case. Anayusa from Missouri, Roger Kelly, is the only other lawyer who has filed an appearance on behalf of the government. And again, that's another thing you have to do if you're going to be representing somebody. In some case, you have to file it with the court, which means then if you want to quit, if you want to leave, you have to ask the court's permission to leave. And if they say no, you have to stay with the case, then you have to stay with the case. James' indictment, like Comey indictment, appears to contain material misrepresentations. Miss James is charged with 2 counts of financial fraud, bank fraud pursuant to 18 U.S. Code Section 1344, and making false statements to a financial institution pursuant to 18 U.S. Code Section 1014. The indictment alleges Miss James signed a second home rider contract that prohibits her from renting the property, yet nevertheless rented the home, thereby violating the loan terms and bank and mortgage fraud laws. All right. Okay. All right. In fact, however, the second home writer simply requires Miss James to maintain exclusive control over the occupancy of the property, including short-term rentals. The provision explicitly permits Miss James to rent the house out. She's restricted only for giving a management firm or any other person or entity any control over the occupancy or use of the property. There we go. We've got two sentences. Boom, that case is done, you know? I mean, of course, that's, you gotta do other stuff, but oh my gosh, they just like hit it right there. The indictment does not allege that Miss James relied on a property management company or other third party to rent out the house. Further, according to guidance published by Fannie Mae in 2019, the longstanding position of Fannie Mae and Freddie Mac regarding mortgages, they back in the second home writer permits property to be rented on a short-term basis within the first year of ownership and for any length of time after that. While it appears Miss James was indeed permitted to rent the property, she does not appear to have done so. Rather, Miss James's grandniece, Nakia Thompson, and her children have lived in the house for 5 years, and Miss Thompson reportedly testified before a Norfolk grand jury that she has not paid rent. On her 2020 tax return, Miss James reported having received $1,350 from her niece, apparently to cover the costs of utilities. So that evidence is pretty significant here. Pretty significant in this case. Miss Halligan's signal correspondence with reporter Anna Bauer. Now we are getting to it, everyone. We're going to have to get our magic wand pen out for this one, okay? Oh, my goodness gracious. So many mistakes, so little time. It's fascinating. Thank you so much, Tay DeLulu. Yes, for sure. Here we go. It only matters that the indictments are made. Right. Which, of course, came from a home builder company. Thinks he's a genius. I know. Yeah, we need the magic wand here. I think we'll go green. I think green's lovely for tonight. All right, let's get into it here. Oh, I know, Anna Bauer. Oh, my gosh. Go, Anna. So Miss Halligan's signal correspondence with reporter Anna Bauer. On October 11th of 2025, 2 days after indicting Miss James, Miss Halligan reached out to Anna Bauer, a senior journalist for Lawfare, over Signal. This is mistake number 1. All right, we'll just note it. Mistake number 1, she reached out to the journalist. Mistake number 2, a signal. Miss Halligan began communicating on the case, including by referring to material she likely learned through the grand jury testimony and documents subpoenaed by the grand jury. That's huge. That's a huge red flag. Hold on, everybody. Hold on. That's a huge red flag. You can't do that. You can't do that. That's not allowed at all here. So, grand jury testimony is so carefully kept private in order to not mess up the possibility of having due process here. So if she's giving information out that she learned from grand jury testimony, like that's a huge issue. Higgs said that. Miss Bauer had posted on the social media platform X the New York Times' October 11, 2025 report that Ms. James's grandniece lives in the Virginia home that's subject of the indictment, and in another post it said, quote, this is important exculpatory evidence. Ms. Halligan wrote that Ms. Bauer was reporting things that are simply not true. Ms. Bauer asked Ms. Halligan to clarify how the New York Times' account of her summary was inaccurate, and Ms. Halligan responded stating, quote, your reporting isn't accurate. I'm the one handling the case, and I'm telling you that, end quote. Miss Bauer continued asking for clarification over the next few days, and Miss Halligan again wrote to Miss Bauer stating, quote, continuing to do what you have been, and you'll be completely discredited when the evidence comes out. Well, now I've got a threat here. I am doing better, Connie. Thanks for asking. I am. Yay. Look at that threat, though. That's like on the record, man. Yikes. All right, so she's now been basically incriminating herself. So, that happened. I know. That's a perfect word, Selson. That's a perfect word. Well, that happened. On October 20th, Miss Bauer reached out to the DOJ's Office of Public Affairs. Let me make sure I'm in frame here, everybody. With additional questions and seeking comment, on which Miss Halligan sent her another text stating, by the way, everything I ever sent you is off the record. So that's not how that works, as I think everyone knows. Oh my goodness. Everything I ever sent you is off the record. Don't send evidence of your own crime to other people. What? They write themselves. Oh my gosh. Well, he may still think she's the greatest lawyer. I think he may have a inability to really understand what that means. You can't come back later and say everything I told you to a journalist and say it's off the record. Like, there's no agreement, then there's no agreement. Miss Bauer explained that that's not how off the record works. Good job. Miss Halligan replied in part, quote, it's obvious the whole convo is off the record. There's disappearing messages and it's on Signal. What is your story? End quote. Yes, to a journalist, right? I mean, come on. So number 2, possible violations. So this first piece was absolute violations. Here's other ones that they're saying you need to look into it to make sure. He looks for loyalty, not qualifications. Well, exactly. I originally thought, and she might be, but I thought she was the one that would run after Mr. Orange with like that portable printer, right? And then if something happened, she would like print something out for him and give it to him. I thought that was her, but I must be wrong. Right. Possible violations of Virginia rules of professional conduct. Miss Halligan's conduct with respect to the charges brought against Mr. Comey and Miss James in her Signal exchange with journalist Anna Bauer appear to have violated multiple rules. A, Miss Halligan may have violated a Rule 3.3a. This is the candor one, right? So the Rule 3.3a1 prohibits a lawyer from knowingly making a false statement of fact or law to a tribunal. Further, 3.3a4 prohibits a lawyer from offering evidence that the lawyer knows to be false. If a lawyer has offered material evidence and comes to know of its falsity, the lawyer shall take reasonable remedial measures. The comment notes section, and by the way, the notes of our ethics rules are just as important as the rules themselves. We even have judges that will go into the notes or the explanations right after the rules and cite those even to support whatever's going on. Real quick, let me just show you what that means, because it's kind of a weird thing, right? So we have a rule, and then we'll just say here, right? So we've got this rule 1.6, confidentiality of information. So we've got A, B here, all the way to the end, right? And then we've got this huge comment section, and this is very, very helpful. So they're explaining then what all of the different words mean and the order of them here. And that's 2 pages, 3 pages, 4 pages, 5, 6, 7.5. 7 pages of comments, for a rule that's 1 page long. So I think that's something that can be very helpful for you. If you're wondering how the rules work for ethics, go to the comments after the rule itself. All right, so we have, and I made a little note so that I wouldn't lose my spot. Now I can't see where I put the note. All right, offering evidence they know is to be false. All right, if a lawyer has offered material evidence and comes to know of its falsity, the lawyer shall take reasonable remedial measures. The comment notes, again, that's what we're talking about after the rule, of the lawyer, here we go, section 8 point whatever, 01 is the big rule here, of the Code of Virginia states that a lawyer's signature on a pleading constitutes a certification that the lawyer believes, after reasonable inquiry, that there is a factual and legal basis for the pleading. This is, again, one of those, Ethics 101 rules. One thing you can always argue on is what a reasonable inquiry means. Like, what's reasonable to you might not be reasonable to others. So that's one. And so sometimes, they can kind of stretch that and say, well, I did make a reasonable inquiry. Potential violations in regard to Mr. Comey's indictment. Ms. Halligan appears to have failed in her duty to be truthful and forthright in her dealings with the grand jury and district court in regard to Mr. Comey's indictment. The indictment focuses on Mr. Comey's testimony in response to questioning by Senator Ted Cruz before the Senate Judiciary Committee in 2020, alleging that Mr. Comey had stated that he had not authorized someone else at the FBI to be an anonymous source in news reports regarding an FBI investigation concerning the president. Concerning person one. Yet during that 2020 hearing, Senator Cruz said that if Mr. Comey's 2017 testimony before the committee, Mr. Comey had denied authorizing someone else at the FBI, to be an anonymous source in news reports about Trump's investigation or the Clinton administration. And this is in bold. Well, do we know? Well, we'll find out eventually. It all comes out in the end, everybody. Emphasis added, the Clinton administration, to which Senator Cruz referred, cannot reasonably be replaced by person one, Hillary Clinton, in the indictment. Ooh, so person one was Hillary. All right. Right. Further, Senator Cruz's questions pertain to whether Mr. Comey had authorized Andrew. There we go. Andrew. Here. McCabe, who had served as Mr. Comey's deputy director of the FBI, to leak information to the Wall Street Journal. In response, Mr. Comey refused to characterize Mr. McCabe's testimony, instead stating that he stood by his own 2017 testimony. The indictment, however, misleadingly suggests that Senator Cruz's questions related to whether Mr. Comey had authorized Daniel Richman, who appears in the indictment as person 3, not Mr. McCabe, the person to whom Mr. Comey actually is referring to, leak the information. So this is getting kind of like jacked up here, right? In this particular situation, it's getting all tangled up, and it's because clearly they did not know the process. And you have to be so careful with grand juries too. I mean, you really do. Ms. Halligan was the sole prosecutor presenting the case to the grand jury. In a case of this magnitude, that's unusual, and is the sole signatory to the indictment. Therefore, all statements before the grand jury, as well as the charges contained in the indictment, are attributable directly to her. And that's a good point, everybody. That's a really good point. She was the only one there. I mean, my goodness, bring an assistant in at least, so there's another set of eyes that can help you prove your case. But she's the only one there. She's just doing whatever she wants to do, even though she's probably never done it before. And then whatever information they came back with, they thought, well, we can indict. But imagine if all of the information they received wasn't correct, wasn't done in the right way. So then their indictment would be crap, right? It'd be rubbish. Your rings. Oh, thanks, Kathy. Thanks. Oh, yeah. I like my flowers. Got to get that out. Gotta get the shinies out sometimes. By providing the grand jury with misrepresentations material to establishing the elements of the charged offenses, and by filing an indictment containing material misrepresentations, Ms. Halligan appears to have made false statements of material fact to both the grand jury and the district courts in likely violations of the rules 3.3A4. I mean, that's huge. That's a freaking huge stinking deal here to do that. I mean, if you want to make your argument, and I have to admit, Mr. Orange's people do this constantly on other filings, but the other filings aren't involving a grand jury, which is like such a huge protected entity, right? So they might say, well, his elevator was 50,000 feet, whatever. They can say what they want on those kinds of motions. But when you're dealing with a grand jury in an indictment situation in criminal court, that's not going to fly here. Right. Oh, yeah. They've submitted all kinds of false information through the civil cases. And again, I went through all 4 of those as they were going on. So, oh my goodness. Oh, thank you so much. Oh, yay. That's my happy dance. So the civil cases as well as the criminal cases against Mr. Orange, one of the things that we talked about regularly was how his attorneys would put information into their pleadings that was not true. It just wasn't true, just blatantly. And the judges would be like, well, that's not actually true, except for Judge Cannon. She did not do that. But I mean, that was kind of, again, like their modus operandi. No judge at a grand jury. Right. I mean, it's all questionable. You need to have some witnesses to help you say you didn't do anything wrong. All right, Ms. Halligan appears to have made false statements, right, to the grand jury and the district courts, and that is a violation of our ethics rules. Potential violations in regard to Ms. James's indictment. Ms. Halligan appears to have failed in her duty to be truthful and forthright in her dealings with the grand jury and district court in regard to Ms. James's indictment. The indictment alleges Ms. James signed a second homewriter contract that prohibits her from renting the property, yet nevertheless rented the home, thereby violating the loan terms in bank and mortgage fraud laws. The second homewriter does not, however, include such a prohibition. Indeed, it appears the form explicitly allows Ms. James to rent out the property as long as she does not employ a property management company or give anyone else control over the occupancy or use of the house. So again, they're saying there is no evidence here. What she did was fine. It was fine. And that's where the malicious prosecution piece is going to come in repeatedly, because we've got people left and right saying, no, we're not, violating any rules here. So this is an ethics complaint that I'm reading through right here regarding Ms. Halligan, the U.S. attorney that has filed and pushed for indictments against Comey and Letitia James. All right, so that's what we're going through here. All right, here we go. And cocoa time. Okay, as in Mr. Comey's case, Ms. Halligan is the sole signatory to the indictment. Therefore, all statements before the grand jury to secure the vote on the indictment, as well as the charges contained in the indictment, are attributable directly to her. And again, you got to understand, if you bring a grand jury in, the most important thing that you're looking for is neutrality. And you're making sure every step of the way is done correctly, because you don't want something like this to happen, because this is grounds, again, for dismissal. This is grounds for a violation of his right to, due process and a fair trial. By providing the grand jury with misrepresentations material to establishing the elements of the charged offenses, and by filing an indictment containing material misrepresentations, Ms. Halligan appears to have made false statements of material fact to both the grand jury and the district court in likely violation of Rule 3.3. So that's huge. They're saying that she lied on an indictment. I mean, that's like Don't do that. That's really bad. In fact, I can't think off the top of my head of what would be worse than putting false information into an indictment, having that indictment filed with, the most precious thing that you have to the court, that the court will try to protect the hardest, is your freedom. And when freedom is on the line, these courts, like, they're not playing around, right? Like, you might say, well, some judges are corrupt. Like, great, people are people. But when it comes to this, like, you put a mistake like this into an indictment, that's like malpractice at this point. Right. Temporary. Yep. All right, next. Ms. Halligan may have violated Rule 1.1, potential violations in regard to the Comey and James indictments. The misrepresentations in the indictments implicate Rule 1.1, which requires a lawyer to provide competent representation, which is what I thought Judge Cannon was lacking here, requiring the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. The required attention and preparation are determined in part by what's at stake. Major litigation and complex transactions ordinarily require more elaborate treatment than matters of lesser consequence. Obviously, most recently, Ms. Halligan was admitted to the Florida bar in 2014 and began working at Cole, Scott & Cassane, which specializes in insurance defense litigation, becoming a partner in 2018. I mean, that's nothing to sneeze at here. That's pretty good. I mean, for her to go in Florida and then work her way up to partner, that's great. It's just in the wrong area for her to be competent for this kind of a case. After meeting Mr. Orange at one of his golf courses in 2021, Ms. Halligan joined his legal team, defending his handling of classified documents and other matters. This would be also called the espionage case, for those who are curious. When Mr. Orange reclaimed the White House, Ms. Halligan joined the White House as senior staff secretary, where she led the effort to remove improper ideology. Whoa. That's so scary when they say stuff like this. Like, yikes. From the Smithsonian Institution and other facilities. She viewed as disparaging to the United States. Displeased that experienced Virginia prosecutors found insufficient evidence to prosecute Mr. Comey, Mr. Orange quickly moved to install Miss Halligan to replace Mr. Siebert, allowing her to secure an indictment against Mr. Comey before the statute of limitations elapsed and to pursue a case against Miss James. He found her at Kohl's. Well, once in office, Miss Halligan reportedly disregarded the conclusions of numerous experienced career prosecutors. This is the other thing, too. My goodness gracious, these people with this, and I'm saying these people with this humongous ego that think if they just scream it or are awful enough, they're going to get their way, right? So she's just coming in here, and these lifelong career prosecutors are saying, dude, this is all messed up. And she's like, I don't care, I'm doing it anyway. That's bad. That's really bad to do that. Like, her credibility now is gone. This will be her reputation for the rest of her life as a lawyer, will be these moments when she treated career prosecutors that way, who had been thoroughly investigated Mr. Comey's statements and found prosecution unsupportable. She then rushed to indict Mr. Comey in just 4 days, apparently failing to properly analyze the testimony at issue, the result of which was that she failed to recognize Mr. Comey's statements were literally true, or at least not provably false. Similarly, it had been reported that Ms. Halligan disregarded the conclusions of numerous experienced career prosecutors who had thoroughly investigated Ms. James's mortgage documents and found prosecution unsupportable. She nevertheless rushed to indict Ms. James soon after she was installed as interim U.S. attorney, again apparently failing to properly analyze the documents at issue. the result of which was that she either deliberately ignored or at a minimum failed to recognize, I think it could go either way, the fact that the second home writer demonstrates Miss James was not prohibited from renting the house. So just the basics here. Right, they have a legal analyst on Fox. What? Oh my goodness. Oh, Miss Halligan reportedly acting alone. Don't do that, Halligan. Don't ever act alone. Included material misrepresentations in the indictments of Mr. Comey and Miss James. Miss Halligan's conduct indicates she lacked the requisite legal knowledge, skill, thoroughness, and preparation reasonably necessary to handle these matters in likely a violation of RPC 1.1. All right. And so that's what happens when, you come. As a side note, everyone, it is not, I guess for me, since the kind of cases I took were whatever was in my area, kind of like a general physician, general lawyer situation. Because for me, as long as it was an area of the law I'd worked in and could teach myself what I needed for the case, I was comfortable with that. But if you're coming in and you're not even trying to figure out how stuff works properly, I mean, that, of course, is a huge ethics violation. Huge. And, maybe she's like, oh, it's a criminal case, blah, blah, blah. But criminal cases are tough work, man. They're hard work. Yeah, bad reputation. Exactly. So, again, this is her reputation. So, going back up here, she began working at Cole, Scott, and Cassane. Great. Which specializes in insurance defense litigation. And, you might get some decent experience here with that. She probably would have experience with what questions to ask, what formats to use, what elements is she trying to get in there. That probably is something that she could have done by, 4 years in the firm. I don't doubt it. But then we've got another question, though. Like, if she was doing so great in 2018, right? But then she met him in 2021, so 3 years later, and then she just walked away. She walked away from being partner of a law firm here in order to join as an assistant, right? So, that's kind of weird, don't you think? East District, U.S. Attorney, right. Oh, that's so sad. They all seem to come from, right. Central Casting. That's a good point. But in reality, you're not going to leave a cushy partnership just so you can, print copies out for somebody. Well, I guess maybe you can, but it's suspicious. All right, potential violations in signal exchange with the journalists. Oh my gosh, I know, right? I'm not seeing anything or hearing anything. Potential violations in signal exchange. Now we're on kind of the home track, the home run. We're on the way home. Oh my gosh, everybody. Oh my goodness, what am I trying to say? Here's the last stretch. There we go. We're on the last stretch. We got it. Woohoo. Oh, you just made some cocoa. Good for you. Yeah, the signal chats, man. Whew. That's not good. And it seems like you would have learned that by now. If you do something that screws something up, don't do it again. Why are you doing this again? What's happening? Miss Halligan's signal exchange with Miss Bauer also implicates her competence. Ouch, yet true. The DOJ has clear rules prohibiting exactly the sort of extrajudicial statements made by Miss Halligan. Duh. The Justice Manual states DOJ personnel should presume that non-public sensitive information obtained in connection with work is protected from disclosure, with few exceptions. U.S. attorneys are required to coordinate their news media contacts with the DOJ's Office of Public Affairs, which I guess they still have, in cases that transcend their district or are of national importance. All right. In her exchange with Miss Bauer, Miss Halligan repeatedly alleged the reporting had been inaccurate and claimed Miss James received thousands of dollars in rent, perhaps realizing her error in contacting Miss Bauer and not setting ground rules for the communication before embarking on an exchange because she was just too excited to have someone pay attention to her. Miss Halligan finally wrote, "It's obvious the whole convo is off the record. There's disappearing messages and it's on Signal." End quote. President Orange's repeated references to Miss James's alleged criminality and his demands that she be indicted raised the case to the level of one that transcends the district. All right, so that burden has been met and is of national importance. The Justice Manual states that in such cases, U.S. attorneys must coordinate their news media contacts with the Office of Public Affairs, which it appears Miss Halligan failed to do. It also appears that by referring to material in the indictment and by repeating casting aspirations on the reporting in the case, Miss Halligan was violating DOJ disclosure policies. Thus, unenforced errors demonstrate that Miss Halligan, who has no previous prosecutorial experience and who only recently joined the DOJ, has not familiarized herself with the department's policies and practices and lacks the skill and competence. This is the one that hurts here, and lacks the skill and competence necessary to prosecute the complex cases against Miss James and Mr. Comey. That's a harsh burn. That's a very harsh burn. Oh, aloha. Yes. It's Aloha Friday, right? Everyone that's gone over to Brino's page over there, hopefully. We love that. We love the Fridays. Right. Well, Mary Mead, exactly. Hello, welcome. All right, letter C here. Miss Halligan may have violated Rule 3.6. Again, we're coming down to the final pages here. By sending journalist Anna Bauer signal messages about the case against Mr. James and Miss Halligan appears to have violated DOJ regulations, local rules for the U.S. District Court of the Eastern District of Virginia, and Rules of Professional Conduct 3.6, which prohibits lawyers from making extrajudicial statements that are likely to interfere with the fairness of the jury trial. Big words here again. If you say stuff in preparation for the trial that could somehow limit or harm the trial, that's not good. That's not good stuff because it makes everything take longer because we got to clean up your mistakes. The home stretch. Yes, Navy Fats. Oh my gosh. Yes. Who's overseeing the case? Well, she is the U.S. attorney in the Virginia for the case. So her boss is going to be the AG, right? They're really, we don't have a set of people watching and making sure she's doing her job because she's being set as the U.S. attorney there. Next, potential violation of 20 Code of Federal Regulations, Section 50.2b. By writing to Miss Bauer, a journalist, why did this happen? Why did she do that? Miss Halligan appears to have violated DOJ regulations prohibiting prosecutors from improperly releasing extrajudicial statements or information. The DOJ regulation states, "At no time shall personnel of the Department of Justice furnish any statement or information for the purpose of influencing the outcome of a defendant's trial, nor shall personnel of the department furnish any statement or information which could..." Here we go. Reasonably be expected to be disseminated by means of public communication. So like a news reporter, right? If such a statement or information may reasonably be expected to influence the outcome of a pending or future trial. Now, there's reasons why we do this. I mean, they're not just trying to be jerks and say, here's some rules, you got to follow them. Like, there's real reason, because if you send out information that's not been authenticated or approved to be used in trial, then because sometimes you don't know your best piece of evidence you could lose in a motion in limine before trial starts, and if that piece of evidence is spread all over the media, then your jury pool is going to be tainted because they're like, whoa, well, this piece of evidence, that's it, I've already decided, and it's going to be really hard for you to make a comeback with that kind of stuff. Right, exactly. No, well, okay. Yeah, I do have my DMs open if anyone's got questions that they would like to ask me, at least as of right now. Although I tell you, they're getting worse, everyone. It continues. Disclosure should include only incontrovertible factual matters and should not include subjective observations. Further, if the release of information would serve no law enforcement function, such information should not be made public. With greater specificity, DOJ personnel are warned to not disclose information regarding, among other things, the credibility of prospective witnesses or evidence or argument in the case. And I mean, this is drilled into us so hard to not have any information be given to the outside. And even I've had cases where my trial's been over and I'm still like, I'm not going to say anything. I'm not going to say anything. Like, well, how's your case? Like, I can't say it, even though of course I can, but we're taught, be careful, again, because you don't want to, poison the whole area, even if you're done. So there's that. Yes, my witchy pen. Yes, and I will just show you real quick as a real quick break for those wondering about my pen. I have several, and it's from Maggie Wand here, and she's an Etsy artist, and oh my gosh, her stuff is just fabulous. It's just very good. It's very good. So I'm not sponsored, I guess. She doesn't know me. We don't know each other, but I really enjoy her work. So there you go. Yeah, don't send inappropriate DMs. Well, the thing is, it gets a lot of paperwork, right? Because then I have to, fill out a form and attach a picture and then send it to the FBI and then sit down and have a meeting with the FBI. And then the FBI is like, we're going to do this, that, and the other. And I'm like, okay, fine. And then they go and they find you wherever you're at. And then they call me back and say they found you. And then you go to prison. It's a lot of work. So don't be inappropriate in my DMs. All right. Oh my goodness. Okay, here we go. The content of the messages Miss Halligan exchanged with Miss Bauer relate directly to Miss Halligan's official work as interim U.S. attorney handling the prosecution of Miss James. She expressed dissatisfaction with the reporting on the indictment of Miss James, warned Miss Bauer that her reporting is inaccurate and that she, Miss Halligan, should know, as I'm the one handling the case. And I'm telling you that, oh my gosh, there's always a couple of these people in law school where the entitlement is like you can't even see. Like you don't even know if they have a face because the entitlement's like plugging the area up. She also advised Miss Bauer to read the indictment. It says she received thousands of dollars in rent, and I can't tell you grand jury stuff. But you did. But all right. She warned Miss Bauer, continue to do what you've been asked and what you have been, and you'll be completely discredited when the evidence comes out. When Miss Bauer asked if Miss Halligan reached out to her just to insult her reporting, Miss Halligan replied, quote, "It was for you to correct it, which you refused to do. You don't report fairly." My goodness. Yeah, Meds goes the same way. Yep. My goodness, seriously, like, oh my gosh. You didn't do what I told you to do. You need to fix that right now. Come on, people. These statements were disseminated by means of public communication initiated by Miss Halligan to Miss Bauer, a journalist Miss Halligan knew to be covering the James prosecution. Her disclosures served no law enforcement purpose and included comments regarding the credibility of witnesses. You can't do that and the evidence in the case. In addition, she repeated claims that Miss Bauer's coverage of the case was neither fair nor accurate. It was an obvious attempt to influence Miss Bauer's reporting, all in an apparent violation of the federal regulation governing the permissible release of information by DOJ personnel. So now we've taken another road, right? Because first it was like, I'm special, pay attention to me. And then if the journalist had had less integrity, right, in that situation, she could have started to change what she was writing, and that would be huge. So she would change the narrative, which is what they were asking. And she's like, no, I've got still my dignity and honor. I'm not going to do that. But perhaps Miss Halligan really thought she was that special, that she was that special. She could go and pick this journalist who's probably working her keister off on these cases, following them for a very long time. And she's like, well, hey, let me give you some information so that you change your mind and then go report it properly. Like, what are you doing? Investigation into the Democrats on the E-list, lock them up and keep them from being... No, I don't think so. I don't think we're in a situation where we're going to have people locked up yet. I think it's way too soon for that. If we've got some kind of indictment or some kind of deposition where some zingers come out for whomever is being called to testify, we might see some indictments. But no, they're not going to be in jail. And they shouldn't be. They should be out there and, responding to discovery requests and answering people's questions. What about for Epi? What about, he's like, he's no longer with us, right? So I don't think he has a problem. Maybe I read that wrong, but there you go. All right, next. These statements were disseminated by means of public communication initiated by Miss Halligan to Miss Bauer, a journalist Miss Halligan knew would be covering the prosecution. Now, I did finish this paragraph, so I'm going to jump down here. A potential violation of Local Criminal Rule 57.1. The DOJ won't try to lock up people. They're trying to lock up the files. Oh, I think that's a great way of putting it. Absolutely, absolutely, because there's two roads, everyone. There's the first road of what's actually in the documents, and that's going to be bad for a lot of people, and rightfully so. The second road is, why didn't the DOJ start taking care of business, right? So we got two roads. One, why don't we have the files? And two, you have the files. Why don't you do your job as the Department of Justice? So that's going to be a difficult one. One can hope. Oh my gosh, anyone on the list deserves to be. Right. And, I agree. First of all, I don't think we're dealing with like a master list, because I think Epi was smarter than that, although you just never know. I don't think we have a list, but I feel like what we have are a collection of communications between people and setting things up, like when, where, why, how, like doing the administrative part of the trafficking of the situation. So I think that is what we really have. And if you pay attention to that, then you can pull the people out that were in it. That's just my thought. Right. It's partisan. Oh yeah, absolutely. Frank, stop being ridiculous. You are like our important election person, so no silly from you. Oh my goodness. I'm just kidding, Frank. Sorry, it's been a long day. Similar to DOJ regulation, the Eastern District of Virginia Local Criminal Rule, not Code 57.1b provides that with respect to a grand jury or other criminal matter, the lawyer participating in or associated with the investigation shall refrain from making any extrajudicial statement which a reasonable person would expect to be disseminated by any means of public communication that goes beyond the public record or that is not necessary to inform the public that the investigation's underway, to describe the general scope of the investigation, to obtain assistance and apprehension of a suspect, to warn the public of any dangers, and otherwise to aid in the investigation. So that's what the rules are here. And they're saying again that she violated that. Now, she violated it by disseminating information. I'm going to sleep with the... Oh, yeah, absolutely. And if it's only fleas you wake up with, you're getting lucky with that. Let's fast forward a little bit here. Again, we're talking about the dissemination of information. She may have violated here Rule 3.8, where you're filing something when you know there's not probable cause. Now, the big thing here, this is the moment when you can tell she's not done any criminal work, right? And I always do this little continuum whenever we're talking about evidence here. Let me see if I can make it a little bit more fancy. My drawings today, everybody. I know Mr. Mayo's like, hey, funny, but he's right. My drawings they're not great, okay? Here we go. So here is our evidentiary continuum, right? Because some people might say, well, exactly what do you need for probable cause? We can't tell you because we don't know. And that's a lot of the things that work in the law. Like you have to pass a test and then you'll know. But until that test gets taken, you're not going to know. So right over here, we have the lowest form of evidence, which is a reasonable suspicion. All right, so we got into the reasonable suspicion piece here from the Terry v. Ohio case. This is what we call like a Terry Pat situation, which is all you need is reasonable suspicion to believe criminal activity is afoot. So they're just walking around here. This guy, gal, fella, person is just walking around. It's the popo, and they're walking around. They've got reasonable suspicion, so they might come up to you and then do a quick Terry Pat and then be like, "What's going on? What you doing?" All right, lowest level. Next up, then is going. Well, we can go a little further. Well, all right. Yeah, that's all right. Is probable cause. All right. Probable cause is set out in the Fourth Amendment as one of the things required for a warrant, the warrants clause. Also, it's needed for any kind of an arrest. You have to have probable cause. It's also any kind of a warrant itself. You have to have probable cause. Probable cause can sometimes get you inside of a car or a moving vehicle because of the Carroll Doctrine, meaning that because the nature of mobility of the vehicle, you need to kind of be like, if there's probable cause, you need to be able to get in there. All right, so probable cause, very, very important. The other thing with probable cause is that's all you need for an indictment. All right, so I try to put it to you like this. If you, well, okay, this isn't legal advice, but if the police or law enforcement is out there and have stopped your vehicle, all right, and you have like written on your head, like I'm escaped prisoner or whatever, all right? It's just right there. It's so clear. So boom, we've got probable cause, right? So that would be the situation, and that it would be the equivalent of what's needed for an indictment. So what I'm trying to say is it doesn't take much. It doesn't take much to get a probable cause finding. Now, once we do that, probable cause, the next area is going to be a civil case. The burden of proof is on the preponderance, you know what I'm saying, of the evidence, which means someone is 51% responsible. We don't know who, but somebody is, all right? No, sovereign citizen, Frank, no. Why would you say that? Why would you say that awful? Why would you say those awful words, Frank? All right, so this is a civil case. 51% it's your fault. And then all the way over here, we finally have beyond a reasonable doubt. All right, so, and this is what we need in our criminal cases. It is the absolute highest burden of proof and should be, because ultimately, if you are found guilty beyond reasonable doubt, you could lose your most important piece, which is your freedom or your life, depending on where you're at. So beyond a reasonable doubt, and these are our criminal cases. Now, again, the reason I like to show it on a continuum is like, let's back up a little bit, all right? So back and up, all the way back here to probable cause. All right, probable cause looks at the totality of the circumstances, puts them all together with the training and education of whomever it is that's going forward, and puts it together, and boom, you've got probable cause. Then even less than that is reasonable suspicion. Now, a lot of people got very upset by the Supreme Court that came down and said the restriction on using race or where someone was working or where someone was walking around or something that clearly showed essentially a racial profile. Those questions couldn't be asked, right? And you couldn't use that as probable cause to go forward or even as reasonable suspicion. So that's why it's so important here. So reasonable suspicion, you wouldn't be able to get that with those factors. What the Supreme Court said then was those factors can be used as one piece of reasonable suspicion and then in the totality of the circumstance for probable cause. All right. So 95% of the totality of the circumstances is not supposed to be racial profiling. But because of the way this Supreme Court is, for the first time, they said, yes, essentially, the racial profiling can be used for 5% of what you're looking for. All right, there's our side quest on racial profiling. Is it frustrating? Yes. But again, it's because they actually they said the words out loud that probably we haven't said in decades. All right, so that was a quick side quest again. So we've got another violation here. Again, we're talking about the probable cause. You have to have probable cause in order to go forward. Oh, thanks, Frank. Oh, you're so sweet. To go forward here on anything, you need to have some probable cause. As an attorney, if you see and you find probable cause, it's fine. And you don't have to be a cop to find probable cause. You just have to have enough probable cause in your indictment so that it can make it past that first hurdle. Because if you're not going to have probable cause even to be able to file an indictment, there's no way you're going to be able to get to beyond a reasonable doubt in a criminal case, which is the goal. And sometimes what you'll do is you'll find probable cause. You'll be like, well, we got some good probable cause here. We filed an indictment. Now we're putting our whole case together. And now that we're putting our whole case together, we're missing some really huge pieces. And there's no way I'm going to get beyond a reasonable doubt. So that's when we start doing plea agreements. So now we need to plead it out. All right, here we go. Probable cause. She doesn't know what it is. She does not know what that is. And so she was struggling with that. I like how they're citing the Justice Manual for her. This provision's echoed in DOJ's Justice Manual, which explains that a prosecutor should commence federal prosecution only if she believes the person's conduct constitutes a federal offense and that the admissible evidence will probably be sufficient to obtain and sustain a conviction. So this is your beyond a reasonable doubt piece. Excuse me. Oh, sorry, everybody. Whew. One more. I keep feeling like we're almost on the last page, and then I just keep giving you all this extra information. All right, here we go. We're bringing it down, everybody. We're bringing it out of the rafters, bringing it down. So no probable cause, that's a huge issue and a violation of Rule 3.8. And then over here, again, they're talking more and giving those specific instances of that here. One thing, though, that I did want to catch was this final piece of probable cause. The evidence appears to demonstrate that absent Mr. Orange's intervention, neither Mr. Comey nor Miss James would have been indicted. Only after the Orange demanded of the AG through a post on Truth Social, "Justice must be served now," was Miss Halligan installed, apparently over Miss Bondi's objections. And Mr. Comey and Miss James indicted. Miss Halligan was well aware Mr. Orange had instated her as an interim U.S. attorney, specifically to indict Mr. Comey and Miss James, and within just a few days of joining the office, she did just that. Despite career officials having found the cases unsupportable by proceeding with charges that career prosecutors, as well as Mr. Comey's case a special counsel appointed by Mr. Orange deemed unsupported by evidence. So the people that work with the evidence, they said there's no case. And by misrepresenting the factual basis of the charges in the indictments, Ms. Halligan appears to have violated her additional responsibility as a prosecutor to refrain from prosecuting charges not supported by probable cause. And everybody knows that, right? Now, you all know that too. So let's move forward here. We've got another violation that they're going into here when they're saying she's intentionally giving false information. Reset gifting goals. I don't know what that means, Viper. Does anyone know what that means? Can somebody do that? I'm gonna have to Google that. I know now. Oh my gosh. Yeah, she's struggling. She's not gonna come out of this looking very good. She's gonna be in a bad place. So we have another potential violation here, and they go through that where again you're not supposed to lie, but that's not they do that here. They do that in this administration. Here's our conclusion, everybody. All right. We will come to, I have no idea what's happening with those gift things, but somebody told me I should do some stuff. So I guess I'm trying to do stuff. I got to figure out more stuff. Bottom line, thank you everybody for all of your gifts. I truly, truly appreciate it. Number 3, conclusion. Here we go. Miss Halligan's actions with respect to the prosecution of Mr. Comey and Miss James and her signal exchange with Miss Bauer appear to represent a serious breach of her ethical obligations. Her conduct undermines the integrity of the DOJ, appears to have violated multiple provisions of the Virginia and Florida rules of professional conduct, and undoubtedly will erode public trust in the legal system if permitted without consequence. The committee has a responsibility to stop Ms. Halligan from abusing her position and her Florida bar license for improper purposes. Failing to discipline Ms. Halligan under these egregious circumstances will embolden others who would use our system of justice for their own political ends. Campaign for Accountability, which is, again, this organization, respectfully requests that the committees in both states conduct a thorough investigation of these allegations. Oh my gosh, what's happening over here? Look at that. Oh my gosh. Oh my goodness. Thank you, everybody. Oh, Willie B. Oh my gosh, everybody, you're so sweet. Oh, that's so nice. Oh, I'm going to have to get some ice cream here. All right, middle of the sentence, everybody. I apologize. Sorry about that. They're saying here, please, we're requesting investigations through the state of Virginia as well as through Florida, where her license was. Ban Fuzzard. What? We don't ban Fuzzard over here. Oh my gosh, what is this? Look at this. It says I'm looking here on the screen, it says some stuff. 22 win, 20. What? I don't know what happened, but thank you. Oh my gosh, everybody. Oh, Paco Taco, thanks. Fight the fascists. Yes, Daisy May Doughboy. Willie B and Navy Vet, thank you. I wish I knew the system better. I'm going to need to YouTube it. But I do appreciate all of you very much. So with that, my friends, yes, I'm going to have to figure that out. I appreciate you so much. Seriously. Quick poll for you to ask a question. Oh, whoops. Oh, dear. I was in a moderator setting, started something by accident. That's okay, John. We're all kind of doing stuff. Like, I don't know what happened here. I just learned it. Seriously, I'm going to have to, pay better attention. All right. Let's do some closure here. We need a little bit of closure. So we do have this ethics complaint again that has been filed. Will it be investigated? Highly doubt it. Florida does not like to go in. Of course, when someone is actively in a particular role, when it comes to the federal government, and, whatever, rules are rules, that's their rules. Did you see Manda's, or do you need to rest? Oh, see you at Manda's. Yeah, I'll be over at Manda's. Yeah, I will rest a little bit here, but of course I don't want to rest too long because I know Army Barbie, she can't stay up too late. So I want to make sure if she's over there that I got her back. So, oh my gosh, those ladies are so fun. I adore them. I just adore them, everybody. Right, no rules ever. Again, this probably will not be done, but it is creating a record. It's creating a record of bad and unethical behavior, and this can be used for lots of different things. So I think that's very important. So with that, everyone, oh, thank you so much for the gifts, everybody. I don't think I've ever really talked about gifts other than to say thanks. And then, of course, my sweet moderators help me out as well. But I appreciate all of you so very, very much. And if you've got questions, of course, just put them on any of my posts and I will do my best. So I will see you later. I'm going to try to hop over with the other ladies so we can cause some trouble. And I'll see you all again very soon. Take care, everybody.